Hello, everybody. My name is James Fitzgerald, and today I will be providing you a presentation about the ethical concerns regarding physical restraint in the classroom or the educational environment. Particularly, this paper more or less targets state-funded institutions, schools, etc. My personal stance on this topic is that physical limitation should not be used in a classroom setting nor any other setting on children with mental disabilities unless deemed 100% necessary in situations that may threaten severe injury or even death to themselves or others. The overuse of these procedures that are commonly used in the educational setting are considered legal and satisfactory should be reevaluated and changed for the ethical and physical well-being of those who cannot self-advocate for the change themselves. Not only is physical force used on a regular basis at many institutions and schools, but the proper documentation and universal definitions seem to be what's lacking in what is demarcated as physical restraint, physical force, guided support, etc. I also touched a little bit on seclusionary procedures as well in this paper, as they are related, and this is actually grouped together with the physical restraint, in my opinion. The lack of the universal definition, as well as how it's documented, can lead not only many blurred lines to what is acceptable, it also negates the parents' wishes to be informed on what level their child is being physically coaxed with an establishment that they trust with their family members. There is an article that I went through that reviews restraint observed in a public school system, which is sometimes unclear whether just grasping a student's hand and pulling them to bring them in a direction would be considered physical restraint, or if it's just known as more of reasonable force. Um, these are all things that were touched on, and what is defined as force and what is defined as deemed to be proper and necessary physical contact. It is not known which of these definitions the pupil would have applied to his experience of this act of handling. Now, a little bit will go on about what ethical violations or dilemmas in particular can be touched on this topic. So the use of physical restraint in schools and similar institutions has become something that not only has become common knowledge, but it's typically legal in most parts of the US. Obviously, the restraint definitions, there is limitations on it. It's not torture by any means. However, when it comes to violating clients' rights, it could be on the same level. Ethical dilemmas have arisen from such procedures, particularly among those um, concerned with the treatment of mentally handicapped. While there are many that advocate the use of such restraints for the safety of staff, the students themselves, the ethical predicament that arises from the use of physical force that can cause severe injury and infringe on the student's rights is a growing basis that is constantly undergoing investigation and research. The usage of a restraint procedure as behavioral treatment has been shown to be an effective reductive procedure. However, it raises many ethical and practical concerns. This leads use to not the practicality of the procedures themselves, but more so the ethical standards that must be upheld to deem them necessary in behavioral interventions in the classroom. Um, Observation of physical restraint in person has actually led me to believe that it is not only unethical, but it's really uncomfortable for all the parties involved. Something should be done to change these procedures, such as more staff training, behavioral interventions that are less invasive, and possibly a review of the current laws and ethical treatment acts that could aid in the advocacy for the mentally handicapped youth of America. Documentation should be required for all coercive measures, whether the caregivers believe they are truly invasive or not, and operational definitions should be given and understood by all parties involved in caring for the student with a mental disability. The following investigation will provide a little bit of an analysis of the effects of physical restraint performed on the students in a classroom or public education setting. As long as there have been behaviorally challenged students in schools and institutions, there have been questions to what rights these students have and contests to maintain them. In the case versus Youngberg versus Romeo, criteria for a typical student is slightly skewed, however the example that demonstrates the violation of human rights is definitely established. Nicholas Romeo was a little bit older than said school-age students that I was talking about today. He was 33 years old, but he had the mental capacity of an 18-month-old. When his father passed away, his mother was no longer able to care for him by herself at home, so she had him committed permanently to a state facility in Penhurst State School in Pennsylvania, United States. While he was housed there, he was physically restrained and the victim of many injuries, which were not only noticed by his mother, but also brought the attention of the staff, who did not resolve the issue. His mother filed a complaint against the hospital staff, alleging that they should have recognized that he was suffering injuries and that they failed to apply appropriate preventative procedures, which was violating his 14th Amendment right of due process and the prohibition against cruel and unusual punishment in the 8th Amendment. Although the first time this case was processed resulted in no change, it was appealed and upon the second trial solidified that rights had in fact been violated and that Penhurst be required to offer adequate training to their staff to preserve Reno's basic rights, as well as others. The court stressed the need for the balance of interests of both parties involved to ensure that whether interests of liberty were being adequately protected. Another relevant court case, which correlates with the lesser publicized seclusion portion of mental illness in schools, is Disability Rights Wisconsin Incorporated, which is actually a private firm, versus the State of Wisconsin, Department of Public, State of Wisconsin, Department of Public Instruction. 2005, a public institution in Wisconsin used seclusionary rooms, which were implicated during the school year. Although the legality of the seclusion rooms was actually upheld in the courts, revisions to them as well as the notification and documentation needed to be increased drastically. The rooms themselves did not have an interior doorknob, which violated fire codes, as well as produced an imminent danger to the students, and the school also was caught not notifying parents when their child was put into the seclusion room, which is what the whole causation of this court case mainly concerned. Not only are they violating the students' right at that point, but the caretakers, due to the fact that the children were under 18, are also their legal guardians, have the rights to know what is going on behind closed doors in the school. The interesting part of this case were the parties interested and the limited amount of information they were able to obtain before getting legal action. Disability Rights Wisconsin had received the reports of neglect from a parent. However, upon investigation, they attempted to get the records from the school, but the school would not give them to them. This was actually flipped in court because DRW, Disability Rights Wisconsin, is a company that basically all they do is advocate for the rights of students. They were required to give the records to DRW after this. They were protecting client confidentiality, which is right. However, the way they did it was a little bit of a loophole that they try to get out of. So upon opening and reviewing the court case, multiple aspects and issues with the investigation became apparent. Legality was fine, however, the staff training was very, very low. Of the two rooms, one was next to the principal's office, which was deemed appropriate, but the second room was nowhere close to any other floors or any other classrooms that were mainstream. Therefore, there was not a lot of supervision to what is going on one-on-one between student and trainee. Although DRW could have contacted every parent of every student in there to bring it to the situation, they chose the appropriate act of going through the legal system, which was appreciated by the courts and made the ruling much more favorable to them. The point was brought to attention that although releasing information to anyone other than the client or student and Legal Garden on the basis of DRW and the advocate group strides towards protecting the client's rights. Over the years of the advocacy for individuals with mental illnesses or diagnosis, there have in fact been many laws passed to protect their rights as well. Many of the laws in place tend to be from the second half of this 20th century, or even more recently, which shows that we are still making progress in protecting those who cannot help themselves and working together for a common cause of equal rights. I'll go through really quick. I don't want this presentation to be forever, but one example of a law that is in place to protect the present population is Protect Program, which is abbreviated PAIMI. One of the most notable and relevant rights brought forward under this program was the right to be treated in the least restrictive way available. It's commonly known as the least restrictive alternative. The underlying legal theory is the state may restrict the exercise of fundamental liberties only to the extent necessary to effectuate the state's interest. In other words, the protection of staff. In lay language, meaning basically, if a person can be treated in the community, then the state cannot confine them against their will to the state facility, where their liberties and rights will be conceded, and doesn't only advocate for the institutionalization, but also applies to the least restrictive physical procedures within the walls of a state facility. This is the part that truly makes an impact on the case for advocating rights of the mentally ill. A separate law is actually, or an act I should say, would be the Children's Health Act of 2000, the CHA. According to this act, it is specified that restraint procedures or seclusion could only be implemented under emergency circumstances. The law also states that this is a last resort to use physical restrictive intervention has already proven to be ineffective. To make this law even more appealing to those involved with mental health advocacy, a subsection also specifies that any intervention is to be implemented by a trained and certified professional in the field. Not only does this specify that the staff member must be well aware of the risks, thresholds, de-escalation methods, and alternative procedures, but also address concerns regarding restraints, procedures to allow problematic restraints, documentation, and follow-up with staff. These individuals were also responsible to have knowledge concerning investigation of injuries and complaints. This is an ongoing procedure that protects the integrity of those who require additional care in their daily educational endeavors and are supported by the state. It is always possible for ethical issues to arise in the United States, especially there are constant concerns for student safety, and there seems to be ongoing mishaps that involve not only the policies themselves, but also the integrity of those who are supposed to uphold them. Controversy surrounds how much physical assistance is required to be ethical in a classroom setting, and finding a middle ground that all parties involved can agree upon provides a challenging exertion. It's understandable completely that employees that directly deal with these children and others who have challenging behavior issues wish to protect themselves, naturally, and others in the case of aggressive or endangering behavior. However, sacrificing someone else's rights when there could be an alternative is not the answer. Guideline 2 of Bailey and Birch actually covers keeping ethical conduct in check, specifically mentioned, which is rights and prerogatives of the client, section 206. Under this section, the behavior analyst is responsible for supporting individual rights under the law. It is also a behavior analyst's responsibility to provide an accurate and current report of their credentials, proving that they are indeed qualified to uphold their responsibilities. Although this doesn't directly maintain or hold up with the staff training, it is important to know that BCBAs and those associated with the board are to have their credentials and records ready to roll. Right now, I'm briefly going to touch on the research portion of my paper. Obviously, I believe that further action should be taken to lessen the chances of injury, both mentally and psychologically, by eliminating or reducing physical restraint and seclusion completely from the current acceptable practices. One article I read by Coyne and Scott provides a great analysis of alternative measures that can be used in crisis situations, which eliminate the need for immediate physical restraint in an educational system. Within their article, they outline clinical procedures where restraint has been deemed necessary and provide a large list of antecedent strategies that can be used to prepare the child for a changing environment. Although this article consists of mainly ideas, it does give great light to those who may not have a behavioral background or experience. It also lists many ideas for strategies that would be during these behavioral crises, as well as a general debriefing from potentially stressful time for the staff. This reading is great for controlling situations where the behavior may be expected and has a great behavioral approach on how to smooth the situation for those who may not be experienced. Another article that I went over went with another humanitarian way of dealing with disruptive and potentially dangerous behavior. Was one that went through mindfulness. Mindfulness is a behavioral practice that involves staff placing themselves in the current situation and dealing with it as it is. Some studies show that the use of restraints was minimized or eliminated when staff were taught mindfulness techniques. Data from this study, which was by Singh N, Lancioni, Winton, Singh A, Adkins, Singh J in 2009, suggested that the staff training in mindfulness was potentially beneficial to both the staff and the individuals with the disability. It was particularly noted that it was effective in reducing use of physical restraints, medication, and aggressive and destructive behaviors. Something as simple as proper training, which is unique to each individual, can prove to be effective rather than jumping straight to the conclusion that physical restraint is the viable option. Comparable results were shown in a separate study by McCurdy, Thomas, Truckenmill, Rich, and Hillis, Clark, and Lopez that promoted positive behavioral intervention. Found that after implementing a system which trained the staff to predict future behavior, be more aware of what each individual had showed in the past, and how to work together as a team for taking physical measures, proved effective in reducing the number of emergency safety interventions, or restraint procedures in this case, in the school setting. The most promising part of this aforementioned study is that it had proven to carry a sustained impact over the course of 3 years. This study had the ultimate goal to promote more evidence-based procedures and practices for the elevated risk student population. Staff training and mindfulness is not the only strategy that can prove effective. Sanders in 2009 explained how eliminating restraint to manage challenging behaviors without replacing it with another tool is not a viable way of improvement, which I 100% agree with. In their study, they first consulted staff to receive their viewpoints of physical restraint, and the next step was training, which was based on previous research that was based on the client's past. If a child was traumatized in the past, you will not make them productive by coercing and controlling them once again. This alone had a significant impact on the staff's viewpoints on the physical restraint procedures. Next step was extraordinary blocking, which entailed the use of soft objects such as pillows, cushions, beanbags, thick clothing, etc., to support a client in crisis and protect the staff. This step actually encouraged the staff to go to look for more funding, more materials, to request other clinical tools that could be used in the crisis for the school, which was great. Excuse me. They were very on board with this procedure. And then obviously the next component, which is one of the bigger ones that is overlooked sometimes, is just physical staff presence. Having more staff may cost more money to whatever institution employs them. However, there's no saving money when it comes to protecting rights. That is not a trade-off. More educated caregivers, the better, and it gives the staff a heightened sense of security as well as support needed in these crisis situations. The government has acted on the abuse of children with the walls of their institutions, but the statistics are still shocking. There's one study that took place 2009-2010 school year where of the sample, 69% of a sample instances reported instances of physical restraint that were performed on students with disabilities. Only 12% of the sample contained students with handicaps. This data alone should bring far more attention to the calamity of the physical restraint usage in the community of those who cannot self-advocate. Finally, what we'll go over extremely briefly will be just a quick discussion. The use of forceful restraint on students within the educational system is outdated and can be replaced by many other interventions. Staff safety is and should always be a concern as well, but the rights of those who cannot advocate for them on their own should be first and foremost concern. Ideally, all parties involved in a crisis should remain unharmed and safe, and staff training can be implemented to reach this goal. More than one strategy has proven to be effective, and I believe that with a combination of all the strategies discussed, a concise crisis intervention plan can be constructed for more or less universal use. Obviously, individualization will be needed, at least within the United States educational system. Some may doubt this is possible, and I do see why, but evidence has shown the efficacy of many other programs that do not use physical force. Client rights are something that are not to be questioned, whether it involves a mental handicap or not. If students in mainstream schools came home with bruises from staff, there would be much more publicity on the topic. I believe that further action will be taken and applied faster than it has been, as well as honestly media coverage in the behavioral community. If anything, those capable should be the voice of reason, sponsoring those who do not have a voice. It's our duty as human beings to protect the others who can't protect themselves. And although I'm not claiming that all restraint procedures are malicious by any means, harming others to protect yourself does not seem right in these types of situations. Completely empathize with the staff and the behavioral crisis who deal with behavioral crises daily and can see how stressful the job could be. But with the proper training and program implementation, I think that the stress of physical restraint could be taken off the shoulders of both the caretakers and the students within the walls. Thank you for listening. I will just show you a quick view of my references and the next page, and thank you again.